Hello and welcome. My name is Lucas Tokarczuk, and here is my overview of the United States Bankruptcy Code. Before we begin, let's define a few terms. The term bankruptcy refers to the statutory procedure by which a debtor obtains financial relief and undergoes a judicially supervised reorganization or liquidation of the debtor's assets for the benefit of creditors. A bankruptcy discharge releases the debtor from personal liability for certain specified types of debts. In other words, the debtor is no longer legally required to pay any debts that are discharged. In the United States, bankruptcy is governed by federal law. The United States Constitution, Article 1, Section 8, Clause 4 authorizes Congress to enact uniform laws on the subject of bankruptcies throughout the United States. Before 1898, there were several short-lived federal bankruptcy laws in the U.S. The first modern bankruptcy act in America, sometimes called the Nelson Act, was initially entered into force in 1898, which established the modern concept of debtor-creditor relations. The Bankruptcy Act of 1938, known as the Chandler Act, expanded voluntary access to the bankruptcy system, and voluntary petitions were more attractive to debtors. The Chandler Act gave authority to the Securities and Exchange Commission in the administration of bankruptcy filings. The Bankruptcy Reform Act of 1978, commonly referred as the Bankruptcy Code, constituted a major overhaul of the bankruptcy system. It covered cases filed after October 1st, 1978. The most important changes to the bankruptcy law under the 1978 Act, however, were to the courts themselves. The 1970 Act drastically transformed the structure of the bankruptcy courts and conferred universal subject matter jurisdiction upon the courts. They were in practice freestanding courts. The expanded jurisdiction was to be exercised primarily by bankruptcy judges. The bankruptcy judges would continue to be Article 1 judges who were appointed for a set term. The most recent change to the Bankruptcy Code involves the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. The act was intended to make it more difficult for debtors to file Chapter 7 bankruptcy, under which most debts are forgiven, and instead require them to file Chapter 13 bankruptcy, under which the debts are discharged only after the debt has been repaid in some portion. Let's talk about court structure. Bankruptcy courts, being federal courts, have exclusive jurisdiction over bankruptcy cases involving personal, business, or farm bankruptcy. This means a bankruptcy case cannot be filed in state court. Attached diagrams provide visual representation of the federal judicial system. As we can see, bankruptcy courts occupy the same spot as U.S. district courts. However, bankruptcy cases can be appealed to U.S. district courts before proceeding to the next step in the process, which will be the U.S. Circuit Court of Appeals. The U.S. Bankruptcy Code has been divided into following chapters. Chapter 7, also known as liquidation. Chapter 9, adjustment of debts of a municipality. Chapter 11, reorganization. Chapter 12, adjustment of debts of a family farmer or fisherman with regular income. Chapter 13, adjustment of debts of an individual with regular income, and lastly, Chapter 15, which deals with cross-border cases involving bankruptcy. Liquidation under Chapter 7 filing is the most common form of bankruptcy. It involves the appointment of a trustee who collects the non-exempt property of a debtor, sells it, and distributes the proceeds to the creditors. Because each state allows for debtors to keep essential property, Chapter 7 cases are often no-asset cases, meaning there aren't sufficient non-exempt assets to fund a distribution to creditors. To qualify for relief under Chapter 7, the debtor must be either an individual, a partnership, a corporation, or other business entity. In cases involving individual debtors, the financial means test must be performed. Also, individual debtors must receive proper credit counseling. All petitioners must tender proper forms and pay required fees. Lastly, it should be noted that in Chapter 7 case, A discharge is only available to individual debtors. Businesses may file bankruptcy under Chapter 7 to liquidate or 11 to reorganize. The purpose of Chapter 9 is to provide a financially distressed municipality protection from its creditors while it develops and negotiates a plan for adjusting its debts. It is typically accomplished either by extending debt maturities, reducing the amount of principal or interest, or refinancing the debt by obtaining a new loan. Chapter 9 does not provide for liquidation of assets. The functions of the bankruptcy court in Chapter 9 cases are generally limited to approving the petition, confirming a plan of debt adjustment, and ensuring implementation of the plan. In this slide, I'd like to briefly talk about Chapter 11, also known as reorganization. It is typically used to restructure a business, which may be a corporation, sole proprietorship, or a partnership. In some instances, individuals who do not qualify under Chapter 13 may choose to use this option. This process may be initiated voluntarily, meaning by the debtor, or it may be involuntary, meaning is filed by the creditors. In Chapter 11, in most instances, the debtor remains in control of its business operations as the debtor in possession, and it is subject to the oversight and jurisdiction of the court. Generally, a written statement and plan of reorganization must be filed with the court. Individual debtors must receive proper credit counseling and, of course, file proper forms and pay required fees. Chapter 12 is designed for family farmers or family fishermen with regular annual income. It enables financially distressed families to propose and carry out a plan to repay all or part of their debts. Under Chapter 12, debtors propose a repayment plan to make installments to creditors over 3 to 5 years. Generally, the plan must provide for payments over 3 years unless the court approves a longer period for cause. Chapter 12 allows either an individual, a corporation, or partnership to file. Individual debtors must receive proper credit counseling, and like with any other chapters, proper forms must be filed and required fees paid. Let's talk about Chapter 13 bankruptcy, which is also called a wage earner's plan. It enables individuals with regular income to develop a plan to repay all or part of their debts. Under this chapter, debtors propose a repayment plan to make installments to creditors over 3 to 5 years. If the debtor's current monthly income is less than the applicable state median, the plan will be for 3 years unless the court approves a longer period for cause. Any individual, self-employed, or operating unincorporated business is eligible for Chapter 13 relief as long as the individual's secured and unsecured debts do not exceed limits set by the code. In order to be eligible, debtors must receive proper credit counseling and file proper forms and pay the required fees. Chapter 15 is a new chapter added to the Bankruptcy Code by the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Generally, a Chapter 15 case is secondary to a primary proceedings brought in another country, which is typically the debtor's home country. Alternatively, the debtor or creditor may commence a full Chapter 7 or Chapter 11 case in the United States if the assets in the United States are sufficiently complex to merit a full-blown domestic bankruptcy case. In addition, under Chapter 15, a U.S. court may authorize a trustee or other entity, including an examiner, to act in a foreign court on behalf of a U.S. bankruptcy estate. In 2016, a total of 794,960 bankruptcy cases were filed in the U.S. As we can see here, approximately 62% of the total cases were filed under Chapter 7 of the Bankruptcy Code. Roughly 37% of the total filings accounted for Chapter 13. The remaining 1% was allocated for Chapters 9, 12, and 15, with no filings reported for Chapters 9 or 15. Let's take this opportunity to summarize everything we covered here today. We defined what the term bankruptcy and bankruptcy discharge mean. We briefly went over history concerning bankruptcy laws in the U.S., which included the United States Constitution, the Nelson Act of 1898, the Chandler Act of 1938, the Bankruptcy Reform Act of 1978, and most recently the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. We also reviewed the U.S. Bankruptcy Code and its individual chapters, and lastly, we glanced over some of the 2016 bankruptcy statistics to visualize the extent of the law. I hope this presentation provided you with some useful info and it did not put you to sleep. Once again, this is Lucas Tokarczuk, and this was my presentation outlining the U.S. Bankruptcy Code.